Hello, everyone, and welcome. I am really excited today to be talking to Max Schrems of None of Your Business. He is the powerhouse behind several very important cases dealing with US EU data transfer. A brief bit of history here. In the first case, many years ago, a case now referred to as Schrems 1, the arrangement to transfer data about people in the EU to the United States, something that was relied upon by thousands of companies, called the Safe Harbor Arrangement, was struck down as invalid. And this led to a renegotiated arrangement for the data transfers that strengthened protection from government access to the information, among other things, an arrangement called Privacy Shield. So Schrems went back to court, fought that, and in the European Court of Justice, abbreviated CJEU, won again, and that got struck down. And now we're on number three. The third attempt was negotiated, an arrangement called the Data Privacy Framework. They keep just changing the name on this. And this had certain components that were designed to safeguard the data protection rights of people in the EU. And we're going to talk about all this and what the state of things is now. I also wanted to talk to you about the kind of different climate now that we have and the different attitude toward regulation that we have coming out of the United States. And I'll briefly plug a book I just wrote called On Privacy and Technology. And in my book, I call for more regulation. I think that the regulation that we have on privacy is just not strong enough. We really need to double down and do a course correction and do more. However, in the United States, the current administration is taking the exact opposite approach. What the Trump administration is doing, it's actually going in reverse, trying to unwind regulation, trying to weaken or to some extent eliminate or handcuff or whatever you might call it, the various regulatory agencies that we have with regard to privacy. Rescinded the executive order on AI, and there's now movement on let's even go more deregulatory on AI and privacy. And so this is now the new climate in the United States that we're dealing with, and certain things that have happened here in the U.S. that I think are going to have implications on on the other side of the ocean where you are. And so basically, what we're going to talk about is what your move is in this chess game, because it looks like there's been a pretty dramatic set of moves over here, and I'm really curious what's going to happen over there. And so I'd love to start talking about two of them. One is what happened about a month or two ago with the PCLOB. This is the Privacy and Civil Liberties Oversight Board. And Trump fired two of the Democratic members of that. And that obviously has some implications because the PCLOB is part of the data privacy framework. So I'm curious, actually even roll back the clock. Even before that, what are your thoughts on the data privacy framework, sort of the culmination of your litigation here? And PCLOB, and then but before this happened to the PCLOB, and then after this happened to the PCLOB.
Mm-hmm. That's a lot to unpack already, but I'll try to start off with like the original deal maybe. So in our view, basically we have more or less the same deal a third time around, and basically what we see is that the, so to say, Supreme Court of the European Union, the Court of Justice, tells the European Commission, who is kind of the executive body of the EU, that can issue these implementing decisions, that you can't do that. And they just basically got one annulled, and then they just issue the next one. And it takes, just like in most countries, quite a good time until you get back to the Supreme Court to actually get it annulled again. So, and one problem in the EU setting, to probably make that understandable, is that in the EU setting, only the Court of Justice can annul a law, not any local court. No one can kind of declare something unconstitutional other than the Court of Justice. So they have this exclusive monopoly of kind of declaring something, as we call it, an annulment, which in the US setting would be a law being unconstitutional. And yeah, so basically they just passed a new one and a new one and a new one. And I don't think there's any substantial difference. What they tried to do on the European end to argue that these data transfers are illegal is that they basically tried to put various elements of US law together. So in very simple terms, EU law basically says that there is an export prohibition on personal data since 1995. That's not really new. The idea is that if you have privacy protections and the data would just go across a border to a country that doesn't have privacy protections, then your law doesn't make any sense. So you need this kind of, as once you have a privacy law, you also need to manage how data goes abroad, because it would leave the space of protection. And in the case of the US, there was never a federal privacy law. There was never this omnibus privacy law as in other jurisdictions that were deemed adequate. So the European Commission can declare a country adequate if they more or less have the same legal structure or level of protection as the European Union, so that there's no need to kind of limit data flows. And this adequacy decision then basically applies to everybody that transfers data to that country. It's like declaring a country, I don't know, for tax purposes the same, and therefore you don't have, I don't know, tariffs at the border anymore. There's something like that is kind of the idea. And what they did is that they kind of looked at US law now and tried to layer all of the elements on top of each other and said, oh, each element alone would be way too little, not enough. But in combination, we somehow, by kind of closing all eyes, pretend this is good enough. And that was largely driven by industry needs, that they basically just said, we want this trade for industry reasons, so we just have to make it legal somehow. And that gets back to your question about PCLOB and now also the developments with the FTC. Is one of the elements was to say, oh, we have various independent bodies that are around that somehow guide that all of this is actually enforced. I mean, we know that the FTC doesn't have a 100% enforcement history of, whenever you file a complaint, there's actually an action taken. So that was already questionable. But some of the commercial parts, which is the rules of what companies are allowed to do with data, if they would break it, you could basically file a complaint with the FTC. That's the redress mechanism for that. Now, they are by law independent. So there was a problem because from the European side, the Data Protection Authority, which is basically what they tried to mirror with the FTC here, has to be an independent body by our constitutional system. So this has to be a constitutionally independent body. Now, they said, yeah, the FTC is, not constitutionally, but, legally independent, and that should be good enough. And that obviously now raises a lot of questions. These people are just actually kicked out, how much that can be maintained as actually being independent. The same thing with PCLOB. I mean, PCLOB is more of a reporting body. It doesn't have any real decisions to shut something down. It doesn't approve anything. It basically, writes reports that we all read. And I guess there is confidential reports that go further than that. But it's more of a transparency tool than really a approval or, redress tool. And their same thing was true, that by law they're independent, but people factually got kicked out now. I mean, that's a factual act. It doesn't mean that was a legal act. That's, as far as I know, all of that is on appeal in the US. So it may well be that, basically the legal system in the US does remedy the situation, and therefore the independence can still be there, which just like factually for a couple of months, a unlawful situation, so to say. That could also be true now. Where it really becomes a real problem is there is no redress mechanism. So under EU law, you also need to have redress. You have to have a court where you can actually appeal. And for that, they built this, even forgot the name, like Data Protection Redress Court or whatever it's called. And that is solely based on an executive order of Biden. So there is no law that guarantees any independence. And an executive order can be, annulled like that and changed. So what we see as a problem now is that if already the ones that have statutory independence are de facto, kicked out, what does that mean for something that doesn't even have statutory independence, but basically just executive order independence? And how much can we argue that? Because this is the main pillar. Like the FTC and PCLOB was like the declaration. The main pillar is this redress court. And that's the one that's only based on executive order. So that's probably a longer bit, but to put it into practice, at the office I'm sitting at right now, I was sitting at until like 1:30 in the morning, and the first day Trump got into the office. And there he was in his big arena, like signing all the executive orders that will overturn all the Biden executive orders. So here you sit at 1:30 in the morning in Austria, reloading the White House page to see if he just killed the executive order that all of this is based on. Because once that would happen, the whole system would collapse. And getting back to what you said before, we have probably millions of companies relying on this deal. And it's kind of like a house of cards. And now, like, it's not just a little wind, it's like a tornado going around. And we're like, this house of cards is basically going to collapse one way or another. So it could have well been that in the moment that Trump would have signed that executive order, literally every European company using a US cloud provider would be acting illegally. And one last thing, just to put in perspective, the General Court, which is like the court below the Court of Justice, the EU level has 2 levels of courts. It's a bit like the DC Circuit in the US or so, where usually these EU cases go first. That granted one guy 400 euros in damages just for an IP address being sent to the US without a legal basis. So imagine you run a system with 10 million people in it that is hosted with Microsoft or Google or Amazon or whatever. And now you have 10 million people that can all ask for $400. That is an amount that is like actually quite serious. And that is a bit the situation we're in right now. So to wrap it up, it's basically a bit of a situation where politically they wanted the deal, even though it was never stable in law, probably. And now when you have a situation where a lot of instability is introduced into that, we're very worried that this will collapse. And probably the one option is that Trump is basically overturning that executive order. It is actually mentioned in the Project 2025 as something to be scrapped. Or the other option is that then the European Court of Justice at some point would say niet on all of that and turn it down. And then we'd be back at a situation where these data transfers do not exist.
Yeah. There's so much to unpack here and talk about. I do want to mention that when it comes to the transfers, I kind of see there's kind of 2 pillars or 2 bases that the jurisprudence is focused on. One is just how close a law is to the approach of the GDPR, and then before that the directive. How close is U.S. privacy protection to what's offered in the EU, because it has to be adequate. It doesn't have to be identical, but at least close. And the first safe harbor arrangement was very much focused on that issue. I didn't think what they came up with in the first safe harbor arrangement was very close, but I think a lot of the adequacy decisions are based on laws that are far short of where the GDPR's protections are. But that said, that's a part of the equation is, are there protections? And the arrangements have all had this component where, there are principles agreed to, the FTC enforces that. So the FTC plays a role in that piece of it. Because we really, without that, there's really no national enforcer to any of this. So that part of the equation, which I see as a whole big chunk of it, is weakened. And then there's the other part, which is your litigation, which was after the revelations of Snowden in 2013, where he reveals that the U.S. government's engaging in massive surveillance. This is, I think, the thing that sparked this whole strike down of the safe harbor arrangement. That not the specific laws regulating the companies so much as the ease of which the U.S. government could access this data to engage in the surveillance without any redress for EU individuals to do anything about it.
If you massively, it's kind of interesting if you look at government surveillance, because on both sides of the Atlantic, we basically see that this type of surveillance under FISA 702 would be unconstitutional. The interesting thing is that the Fourth Amendment only applies to U.S. Persons, like permanent residents and citizens. So in very, very, very overly simplified version, what 702 from a European directive does, it basically, or perspective does, it basically just splits the data into two buckets, like American data and non-American data. And on the one, everything is unconstitutional to ever touch it. And then the other one, basically, it's fair game. And that is obviously, from a European perspective, not overly acceptable if all your data goes into that system. And I think, to kind of on a positive note, which we're not going to have probably the next couple of years, but in the long run, what we always thought would be useful is to have a kind of what they call a no spy agreement, so that basically among democratic countries, they have an agreement to say, okay, if your data goes across the border to another kind of country, then there will be kind of baseline guarantees like judicial approval before, and some probable cause test, whatever it is in detail. The interesting thing is we agree on these tests on both sides of the Atlantic. There is really not a big discussion on government surveillance. Interestingly, government surveillance-wise, the US usually even has stricter laws than the European countries. So when it comes to government privacy, the US is usually stricter. When it comes to kind of commercial privacy, Europe is usually stricter. So that would have been solvable. But at the time, I mean, we're now in a massive de-integration situation where I think that it's just, I mean, politically not going to happen for the next couple of years. So we'll have to navigate that time in between. And to a certain extent on the European side, that will basically be, sovereignty in the sense to build your own systems, to just not host in a US provider anymore. And it was interesting because I see that in like legal conferences, business conferences since Trump took office, that suddenly people are also politically very serious about. I mean, there's the whole legal side of it to say you're not allowed by law to do that, yada, yada, yada. But because we have almost no enforcement in Europe, they basically do it anyways. But now the political side comes into it, that just decision makers are so fed up with basically the situation politically that they just want to take action in their little bubble, or that they don't feel that this is stable anymore. To give you an example, I was just at a conference, I think 2 weeks ago in Denmark. Now, with this whole Greenland absurdity of a discussion, I was like, the discussion I was just bringing up, said like, I mean, the US just has embargoes partly on countries like Cuba or whatever. It would be possible that there is a US embargo on Denmark tomorrow, because Denmark, I think, has 5 million people or something that's really irrelevant from a US perspective. And that would mean that basically Microsoft or Google or anything they use to just work every day and to have their economy running would have to shut them down. I mean, it's not like something I expect to happen tomorrow, but it became suddenly within the realm of possibilities, like still a 1% possibility or whatever. But imagine one of the biggest shipping organizations in the world, or the biggest shipping organization is Maersk. It's a Danish company that literally could then not, open their I don't know, Outlook or whatever anymore. And that just, they have to now deal with this possibility that some crazy guy will just do that. And now you have to basically say, okay, we have to basically get back to a European provider. We have to get out of this mess. And that's very harmful. It costs a lot of money. It costs a lot of really waste of time and energy of everybody. But these discussions start to happen now, and that's quite a new dimension that we didn't have before. Before, it was more like, okay, the US government can check on our politicians. That's not all too cool. To give an example, the European Commission basically uses Microsoft 365. So if they now draft a memo about what they're going to do in an embargo situation, the NSA is reading it live, which just doesn't make all too much sense for them. And that was more what we discussed. But now it's really a bit more broader businesses that suddenly are okay, what would actually happen to me tomorrow if this happens?
Yeah, I mean, there's a lot of there's so many things to directions to go in. One thing is that and I do want to explore it a little later, but bracket it for now is what moves does the EU make? This could be the opportunity of the EU to kind of build a more robust technology industry and have its own Microsofts and Googles and so on, and realize hey, you can't be dependent on big tech. the moves that were made, that we've seen made now in it's the firing of the two PCLOB, the Democratic folks on the PCLOB. And then there was very recently, just a week ago, the two FTC commissioners, two Democratic FTC commissioners were terminated, I think illegally by Trump. The FTC is a bipartisan independent agency. It's supposed to have no more than 3 commissioners of the same party. So, there needs to be at least 2 Democratic commissioners. Now there are none. So the 2 got fired before their terms are up. These are folks that are appointed by Congress. They can't be terminated. The agency is independent, so they're not at the beck and call of the president. However, one of the things the administration is trying to do is push challenges to the whole idea that there could be an independent agency. So the case in the Supreme Court, a very old precedent called Humphrey's Executor, is now in doubt as to what the Supreme Court will do with that. So I think they're kind of pushing the challenge. I think if they have their way, right, they would essentially get rid of the whole idea that there could be an independent agency. We might not have them in the future. Right now, we still do. So under the existing precedent, everything that's happened is just totally not okay. So there's those moves that have been made already, and then there's the possible rescission of that executive order. But I think even without that, just on those moves alone, what is your I guess what is your move in this chess game? 3D chess, 4D chess, whatever we want to call it. Where do you go first? Are you going to go first to the commission? Do you go to the court? Do you do both? What are you're going to, or can you disclose your plans?
To a certain extent, we've said that a couple of times. So the problem for us is there is the reality is we're a small organization, we're 25 people, and we're basically donation or funded. So you have to pick your battles. And for the data transfers, to be honest, it also intellectually got just so fucking boring, because what is the Court of Justice going to say the third time around? Basically the same thing. So invest hundreds of thousands of euros into a case, thousands of hours. The last time, to give you an idea, Schrems 2 was an Irish case, which is inherently expensive, and just litigation takes forever there, and it's just insane. But the overall cost, like the legal cost for that, was about 10 million euros. Now, we have a loser pays system in Europe. So if I would have lost that case, I would have been liable for these around 10 million euros. Just, to put a bit like real numbers around this. And there are other options to go. One of them is that you can also file a civil law injunction in another jurisdiction. So you basically go against one company and say, I stop my data going over there, because I think this whole deal is illegal. Now, as I mentioned before, only the Court of Justice can declare something unconstitutional, so to say, or annul it, as we call it. So any national court has to make a reference, what they call, to the Court of Justice. They basically you have a local judge in a member state that then sends the case off to Luxembourg, where the Court of Justice sits, on one specific legal question. So not the whole case is looked at, but just one question, which is a reference question. So you say, is decision whatever the new deal is number valid under EU law in light of these 5 other articles that are higher ranking? And that is basically what you need. So typically any first or second instance court can do that if they feel like it. They usually don't. They just reject the case and send it up. And then the last court nationally, which is like in Austria, the Austrian Supreme Court, for example, must make such a reference. So if you're the last court in a row, you must, anybody below can. And that is a typical way that you would get a case to the Court of Justice, on like much lower fees and costs, and probably quicker than in Ireland. In the Schrems 2 litigation, I was a defendant. I didn't ever choose that case to happen. I was basically put on the defendant's bench by the Irish regulator. That's one path. The second option that may happen is that this executive order just gets trashed, or that all the functions around it are just so rotten and falling apart that the commission itself cannot legitimately stand there and say this deal is still a deal. and would itself basically pause the application of this deal or stop the deal as a whole. So far, it's quite interesting because the European Commission is still like, oh, we totally believe in everything, because basically European industry wants that to a certain extent. In the European industry, different parts, the people that use US services, they have no interest in changing because that creates costs and time and, but then the European tech industry obviously is a bit like, that's super unfair because they don't follow any of our rules and are still on the same market. So the European market thing is not a monolithic block. You have different players that have different interests. The Commission so far basically doesn't say much, which I find quite problematic because they tell companies, okay, this is good and just continue, which they may have to shut down in a week or two. So like there are literally billions of euros investments made in all these systems on a very wacky legal basis. And the Commission doesn't even warn European business to say, guys, maybe this doesn't look all too good. Even, they could at least blink in that direction. They don't do that yet. And the last player in all of that is the regulator. So basically the data protection authorities in each member state. One thing to understand is the European Union basically is purely a legislative body largely. There's very tiny executive elements of the European Union. And basically the enforcement of the GDPR is done by national executive bodies. So that's the independent authorities in each member state. And largely so far, when it came to data transfers, they've also absolutely turned a blind eye on it. So they just absolutely didn't want to touch it. And that's true still today. So I think what we'll see probably gradually is more that businesses are partly starting to say we can't do that. What we also see is that US companies are blinking in that direction in Europe, so that they suddenly say, oh, we're going to do a host in Europe and we're going to uncouple Europe from the US and so on to be able to sell these products anymore. So we may see some movement there. Then the Commission, as I said, may just terminate it. If nothing of that actually happens, we'll just have to go to court another time. But to be frank, we have so much other stuff to do that ideally, if everybody plays their role that they theoretically have, they should take care of it and it shouldn't take us. But that was true before as well, and they didn't do it. So who knows where we're going to end up with this. So I hope that gives a bit of an overview of possibilities. And some of them are actually, for example, the Court of Justice must take each case. It's not like in the US where only a handful of cases are ever reaching the Supreme Court. We have about 800 cases at the European Supreme Court per year, even more of it. So that's quite accessible. That's quite easy to get to. But you must basically get a national court to refer it. And there, you're sometimes a bit of at the grace of each judge to actually take care of it or not. Our view is that in this case, judges are probably going to refer it because they're like, GDPR, data transfers, US surveillance law, I'm just fucking happy not to deal with it. So I'm just going to send it off to the Court of Justice. Yeah. That may be the reality, how you end up there. But that's a bit of an overview to give you an idea. And just a certain extent, it's not as much as in the US where just whoever has the deeper pockets really has a fundamental edge, where usually it's easier, even if you don't have deep pockets, to actually get to justice. But for example, Schrems 2 was about 45,000 pages that they produced. It's just like someone just has to read that stuff, even though if most of that is just absurd, crazy, never read by the judge, totally ignored by everybody, but you at least have to kind of like digest all of that. And that is where big tech is quite good at just producing crazy amounts of nonsense, just to basically make it impossible for anybody to litigate anymore, also for the courts to even deal with these cases anymore. And again, that's a bit of a question of jurisdiction in Ireland. That's possible in other jurisdictions. In Austria, there is a kind of the saying: if your lawsuit has more than 10 pages, no one in the world reads it, not even a judge. So you must be short and concise. Or in Sweden, we have oftentimes judgments of 2 pages or something that really say everything that needs to be said oftentimes. While in other jurisdictions, you have like hundreds of pages. So we can choose that a little bit because we can choose the jurisdiction where we bring cases.
Yeah. So a bunch of questions, short follow-ups to this. One is, are there any mechanisms to petition the commission or kind of get input to the commission, or they just kind of do whatever they want? They're like, the president, the executive here in the U.S.
It's pretty much the same thing. There is an official thing where you can file a complaint and you can basically do all of that, but it's like sending a letter to the president. So if they just don't feel like it, it's not going to happen. And right now, I think they're still a bit so in the very first moment, I think on a European end, no one wanted to throw the first stone, so to say. So they were basically saying, let's wait and see what the US does. We don't want to, start a fight over the data transfer deal that then basically gets it into a tariff fight, that gets us into a tariff counterfight, that gets us into whatever. I think that was the first couple of weeks of the Trump presidency where that was maybe the feeling of like, let's wait and see and let's not start a fight. The reality is, I think by now everybody realized we're going to be in a fight sooner or later on something anyways. Like this is basically like that guy is just, it's absurd. You just can't discuss it. Like there is no normality to any of this. So that may change the narrative here, is to gradually say, I think what they should do is to first go out and tell European companies, guys, this system may end soon. Get prepared, get your ducks in a row, get an alternative, look at your options. We're not going to throw you into the cold water tomorrow, but just start learn how to swim, because you may need it pretty soon. That would be the logical first thing to do, and then sooner or later you probably kill that deal, or make it not. They can do variations of making it not applicable to certain situations and gradually walk it back and so on. If they kill the executive order tomorrow, then basically almost any European company is basically acting illegally tomorrow then. And that is the situation. What is added to it, to get maybe to the enforcement part of this conversation, is what's newest since last summer. We have a European kind of collective redress directive, which is, in Europe, we're not allowed to call it class actions because that's an evil American term. So we call it collective redress. It's a bit of a different system. It's opt-in, so you have to get consent by each person you represent, but that can be done electronically and online. And that could change a lot of the enforcement possibilities, because we did first calculations. So it has to be done by a nonprofit organization. So the idea is to take it away from big law firms that just make money with class actions. It has to be run by a nonprofit organization. So we got qualified for that, which is a huge process that you basically got all the bells and whistles to actually bring cases like that. But the first kind of on smaller companies, the first calculations we did is that most of them would go bankrupt. Like the reality is, if you're a data broker, they oftentimes don't have much revenue, they don't have much profit, they just shove around the data of millions of people. And each one of them gets probably $100 or so. And if you multiply that, they're basically going bankrupt over a case like that. So that could be quite an interesting situation, even for big tech, because that money is actually paid. That's not like regulator fines that are actually never paid and negotiated down forever and sit in courts forever. And that could change a lot of the calculation, because so far the calculation was like, Europe is kind of cute with all their laws, but it's not enforced anyway, so whatever. And it especially is interesting because damages are usually backward facing. So it's basically all the dirt you have in your basement is going to be looked into. And for 10 years, they thought, oh, nothing is going to happen because the regulator is not going to do anything. We hide in Ireland, we hide in Luxembourg, at some place where basically big tech is sheltered from EU law. But that doesn't save you from redress cases and from damages cases. Yeah. And that could change a lot of the calculation also for the data transfers.
Yeah. I mean, it's interesting to hear you talk about this, because it sounds like a lot of the impact of this seems to fall on the EU companies, which is kind of weird. Like it's almost like friendly fire, when I think a lot of the whole cross-border data transfer restrictions and a lot of these protections are really have in mind, the big US data behemoths, the tech companies, the data brokers, the other companies that it seems to me that was the biggest concern in the EU. So it's interesting to hear that like the EU companies are the ones that kind of are in the crossfire.
Yeah, it's quite interesting, and sometimes in the US debate, because it's like seen as an anti-American European move to have like data transfer issues. It basically hurts European businesses more than American businesses. So it's quite interesting, because sometimes in the US debate, because there's just, to be frank, just not the knowledge of how European systems work and how that all interacts with each other. There's oftentimes this idea is that this was brought by by European companies to kind of go against American companies. It was like, I mean, there were rumors that we would be sponsored by people to actually, do shit like that. But it's quite interesting, because it's more the other way around. It's really European citizens versus business in general, no matter if it's American or European business. And to add to what you said, it's a very interesting situation, because only if you have a European business sending data abroad, you actually fall under these rules. If a European consumer directly sends data to a US provider that simply is not just sits, let's say in California alone, then that wouldn't be a transfer. They wouldn't even fall under these rules. So it's more of like why the big tech companies are under it, because they usually have a European subsidiary, and they say, for whatever crazy reason, I don't understand why they do that, they say that basically my data first goes, in this case, to Meta Ireland, and then Meta Ireland exports the data to the US. That's how they say on paper that their system works. In reality, it just goes to some server. And that basically opens them up to this question, even because they are exporting the data. If the user exports the data directly to a foreign company, you don't even fall under these rules usually. So you can host your data as a citizen with North Korea if you want to. It's just that you cannot go to European company and data and ship it on to North Korea. That's kind of the situation.
Yeah, so I mean, in a way, like, this might be, limited in a bunch of ways by just the structure of the system. It seems like something that could be, companies could do an end run around. There's also, and then there does this help the EU to, stamp its foot down and say, no, we're going to insist on principles. We're not going to stand for, what this administration's doing. And it kind of like, at this point, like, there's not a lot of folks standing up in the United States, and a lot of folks are folding with the administration. So we're kind of looking to you, the EU to jump in there and say, hey, come on, take a stand. To like,
I think that's going to be really interesting. I mean, I don't know the answer to that, and we'll probably know more even in a couple of months. But I think so far the role of the European Union was to basically have at least regulation, like to at least have some rule to say that's not legal. The enforcement bit so far was pure on the performance. And so where I always joke is like, we're great at having like all the principles in law, but then, if let's put it that way, it's a bit of a cultural element as well. It's like, we usually don't have this super aggressive non-compliance with law. That is also, I mean, even in the US setting, a very Silicon Valley thing, just to aggressively ignore the law, or just to aggressively see how far you can push it. So I think to a certain extent, when big tech came around in Europe, which is, I mean, just 10, 15 years or so, our systems are oftentimes not ready for someone so aggressively ignoring the law. And that needs to catch up. And to be honest, I'm also like not a fan of that, because you basically have more aggressive enforcement then, and you basically just have a more and more and more aggressive legal system, which I'm personally not a fan of. Like, I think people should generally be reasonable and follow the rules, and then we don't have any of this shit. But that's the reality of how these companies operate, and Europe has to catch up with that. And it's for example, procedure rules that are made for reasonable people. But if you have super unreasonable lawyers that are just going to push the boundaries to every extreme, sometimes the regulators just don't know how to deal with that. To give you an example, in Austria, usually if there is a hearing, people come to hearings, then Microsoft basically just sent them an email saying, oh, the next time we can come is in 6 months, which is like, Microsoft has like 300 people working in Vienna. It's ridiculous. But the regulator just didn't know what to do, because like, are they going to send the police car now to kind of drag some Microsoft executive into a hearing? They've never done that in their life. And I was joking, it's like, if it would be a refugee, they would be dragged, by under the same law by the police car. So why not, go ahead. And if that's the way that they play it, then probably have to do that. So to give you, that's a bit, I think, the reality. What's really interesting on our end is, I think it's very different per member state. So for example, France for a long time had this discussion about digital sovereignty, as they call it, to basically say, let's have our core services, at least within Europe, somehow safe, somehow that we can rely on it, that if shit hits the fan, that basically it still works. Austria, for example, doesn't have that as a policy, but factually we do that. We factually just have the government services that still run the digital core services locally on our own servers in the mountains, basically. And then, for example, Germany usually had the total sellout. They just don't have any capacity to really do stuff like that properly anymore, and it just outsource it. So it's per member state very different. And Germany always was a big transatlantic player, basically always big trust in the US, never criticized the US and so on. While, for example, France was much more like, oh, we're not sure about this part. So or we are a neutral country, we're not even NATO member. So each country is a bit different in this. And it's going to be interesting how that changes, because I think the big like pro-US, let's just close all the eyes and pretend it's all fine, thing is gone. Like even the Germans are now totally U-turning on this and say, okay, we just cannot pretend we can trust this anymore. I think everybody really with a very sad perspective on this, like with a really like, it used to be that democratic countries worked together and, had common interests, and it was not transactional. It was about being a democratic rule of law country where it's the democracies versus the rest of the world. That was usually how we all lived for 70 years. If it's now becoming a transactional, how much can I get from you, and I don't care if you're democratic or not narrative, that fundamentally changes the situation. And what could happen in a positive vision is, I mean, there's going to be a debt. There's going to be, just if systems are broken apart that worked for 70 years, it's going to be bad for everybody to a certain extent. And I think what may change, and I mean, the first idea was that, okay, the US is bigger, like not versus the EU, but if you take Canada or something, but if the US picks fights with everybody in the world, you're going to have a situation where the US has fights with 100% of its trading partners, and for us, it's like 15%. So then you're the bigger guy basically in the game, and you may win this because we're still trading with everybody else, and we're like, so that's going to be interesting how all of that plays out. That may, I actually joked about, I think 2-3 weeks before DeepSeek was the big discussion point. I was joking with friends is like, usually when they cut you off or when there is disintegration, it takes a bit, but then you grow your own local business and you grow local competition and so on. And that oftentimes overtakes the original one sooner or later. And that's exactly, if you look at DeepSeek, what happened. They basically cut China off from the chips, and they had to come with a more innovative way to kind of do AI. And I think that may also happen here. But I mean, all of this is like not productive, not useful. It's, it's if 5 people that are good at different things work together, it's always more efficient than having 5 people figure out all the shit themselves. So I'm not a big fan of any of this, but it's in reality probably what we're going to see. And the way to explain that the best is exactly like AI chips, for example. So, I mean, we get the designs from the US basically, but then the lithography companies, as by now a lot of people know, is usually from the Netherlands. That's the only company that can do lithography that small that you can actually have a 4 nanometer chip. I actually talked with a friend that is atomic physicist, and he said, actually, there's one company in Vienna and another company somewhere else in Europe that is the only companies in the world that can do the stencils for these chips. So there's someone sitting here doing the fucking stencil for this. Now we send all of that stuff to China, to Taiwan, where they actually print all of that and produce the thing, and then in the end it gets back into an American box and has an American label on it. And it works, like it produces, good quality chips for everybody of us, and it's an efficient system. If we start breaking that up, everybody of us is going to have a problem, because and so it's not useful. But we're probably at the position where we'll have to, get alternatives and look at these things, and that may oftentimes then mean that suddenly there's a competitor that may do things differently and better, and also on a global stage suddenly you grow competition that you wouldn't have had if you worked together. But
So I want to get a couple of short specific questions, and then kind of go back to our meta discussion of kind of the general direction of the kind of global democratic ecosystem. So specifically, I guess if you were to try to get the court involved, I mean, one is well, maybe the commission will rescind the deal, maybe they won't, and that kind of gets into there's a lot of reasons, political reasons why getting rid of the arrangement and stopping the data transfer could really really hurt everybody, right? So that they might be reluctant to kind of say, okay, we're gonna do this, but we're gonna damage ourselves in the process.
Yeah. I mean, there's no political will, if at all. Then there is like a just legal reality that they have to comply with. I think that's pretty obvious. Yeah.
Then do you go to court? And if you did go to court, like would this take a long time, right? It would probably be something where we're talking, because you're not in court yet, right? So this would be a very long process. How long would we have to, like, when would the CJEU be striking down the data privacy framework?
Yeah, so if it's purely courts, you basically need a country that makes a reference rather soon. So you talk about Austria is one of them. There are a couple of other countries that are an option as well. You'll probably get a reference in a year or something. The Court of Justice originally, and that's what I'm a bit worried that I haven't done at the time, but other issues. The Court of Justice could suspend the deal for the time that it reviews it. So that would mean that basically already from the get-go, the judges would be like, we have seen it twice. It's the same shit. What is, the likeliness that the end result is like you can't do it is very high. We have millions of people's data who that goes abroad, and that basically is on the line here. So we have to protect the fundamental rights of people there. That could be an argument that it's postponed, so to say, the application, or that the application is paused. Now, that hardly ever happens at the Court of Justice, so that's a very exceptional move, but it could be a move in this case. It would have been much more likely if we would have brought it right away after the deal came around, because then you could have said no one has much trust in this deal yet. It was just issued, a couple of months ago, so by the week that we don't issue that, that's less likely. Then, so let's say you're at the Court of Justice after a year, this does not happen. Then you basically, on average, have 1.5 years at the Court of Justice until you have a decision from basically the reference to the final decision. That could be shortened a bit here. And like the Schrems 1 and 2 cases were actually a bit shorter than average. And it could be shortened even more here because, quite honestly, same judges read it, the same case a third time. So, and that could get you a little bit shorter, but you're at the bare minimum talking about 2.5 years. Okay. The reality is litigation never works as you expected originally. There's always some loop and a prom in between. So that could take a bit longer then. And it strongly depends also on the judges if they make a reference or not, and so on. Also for that, there are statistics. So you can basically look at countries that are very reference friendly. So you can say how many references per member state do you have, and certain countries have almost 0 references because the judges never do that, and other jurisdictions have a lot of that. So you can, increase your odds there.
Yeah. So I guess then, I'm wondering kind of that there's a big political decision that, the EU has to make. And I'm not sure, everyone in the EU is on the same page of it, is, kind of what to do in light of this administration's not really following the law that well, which is, I think, an assumption that you had before the administration. The other is the kind of deregulatory push that's coming out of this administration now, and I think we're seeing kind of the winds of deregulation start to flare up. It was, not too long ago, the AI company said, please regulate us. And now I read today a story where they say, well, actually, this is great. Deregulation. We love it. Yeah. And so I wonder to what extent will, EU could kind of catch the virus, could do more deregulation, could EU kind of move into a more, let's kind of compromise and capitulate and wear this out, because if we fight, we're going to hurt ourselves in the process? Or do you think the EU would kind of double down and say, no, we don't like this direction, we want to push against deregulation, we want to double down on enforcement? What's your sense for the wins in the EU and the political hunger to fight, or just try to somehow grin and bear it?
Yeah, so I think the discussion actually in Europe started before the Trump administration had the push here. So the one thing that's cited all the time is the Draghi report, which is like the previous head of the European Central Bank that basically wrote a report that we need to, I wouldn't say necessarily deregulate, but part of it is just to cut the red tape and a lot of duties that are just really don't make too much sense. And that, again, is very different in the legal culture. And we don't have one single European legal culture. We have extremely different approaches per member state. Austria is probably, and anything I say, probably think about this back story of myself. The guy that wrote the Austrian Constitution was the forethinker of, I don't get the English word right now, the pure theory of the law. So basically a very natural sciences approach to law, very like logical, technocratic way of law, not total opposite of the common law system, basically. And we usually have very short, pointed law that just is what they usually say, like the legislator should write like a farmer, like the most simple wording you can imagine, but think like a philosopher at the same time. And that is like how a lot of my legal history and legal culture is. The European level is oftentimes very diplomatic, and that ends up with like vague wording where everybody could compromise on this wording, and sometimes they can't compromise on hard rules, so you have like reporting duties instead of that, and a lot of this stuff is very European law-like. And that is oftentimes something that doesn't really help people much, and we have that in the GDPR as well, like just parts that are just internal compliance stuff, where as a user you have no benefit from it. Like all these risk assessments always come out that there is no risk. Like I've never seen a risk assessment that stopped any company to do something. And at the same time, it's a lot of money and energy spent by companies to do this stuff. So there is a bit of a push to say, let's look at that more. Let's look at the, kind of really the red tape, so to say. And that is traditionally, and that's always amazing to my American friends, way less in Europe. Like I always joke of friends of mine just adopted a kid. The contract for that is 1.5 pages. And now a Microsoft software contract is like 5,000 pages. And, it's like, so this kind of, sometimes I think what's, for me, the discussion is not necessarily more or less regulation, but good regulation. So if you have a well-regulated market where certain things are just, you can trust it and you don't need to put that in each contract individually, you don't have to enforce each contract, you don't need to sign 1,000 NDAs, you don't have all this clutter, that can overall for business be more efficient than a unregulated situation where all of that needs to be done per transaction each time again and again. And that is a bit negotiated each time usually with companies. So that is a bit, I think, the vibe that I get, and that would I would personally support as well, because I usually joke around the GDPR. It's the best example of like a simple law that worked for 2,000 years is murder. Like that was ever since the 10 Commandments, that you said, okay, if you kill someone else, that's not okay. And we still have pretty much the same sentence today in the criminal code in Austria, but we don't have a risk assessment of the likeliness that you kill someone for a bad reason, and then like a 5-pronged test that then needs to be documented and then renewed each month. That's not how we regulate murder. And I think for digital regulation, to a certain extent, we would have to go into that direction as well. The worst case example in the other direction is probably the AI Act, if you look at it, which is very much going into kind of compliance and paperwork stuff, and not in like clear rules. And I think that was very much criticized for various reasons. So, and the political context of that is just recession in Europe. It's just economic issues that we have, especially since Ukraine. Vienna was one of the biggest hubs, for example, for Russian gas, because we're a neutral country. Historically, the gas went through us before it went to the NATO countries. That was simply shut down, and just to have your whole economy suddenly not having electricity prices just doubled suddenly, and you have to run businesses on that, and that was just a major drain on the economy. And inflation in Europe was like 10 times worse than in the US, and you already know how bad that was in the US for a lot of people. So that is kind of the background of the discussion, not necessarily what Trump is doing. The background is like the reality on the ground, that we have to get stuff going and have to make sure that that works. And I think that's a discussion that is reasonable, so to say, in various ways. I may agree and disagree with parts of it, but that's a bit, I think, the overall background. And I think we're pretty much at the point where I think if the US does something right now, the appetite in a stomach feeling for a lot of people would be to do the exact opposite, just out of principle, because they hate Trump so much. And that may be a bit more the political reality, that they would do exactly the opposite. If that's always smart is a very different question. But I think that would be my personal feeling. But there are other people that work more in politics than I do and know more about that.
Yeah, no, it's fascinating what you say, and one of the things I actually argue in my new book is, when we're creating regulation, I think regulation's good, but it has to be the right kind of regulation. And I totally agree with you. A lot of the regulation, we're really not getting the kind of practical real results that we want out of it. Companies just kind of spit out paperwork, and they're very good at it. I think a lot of the individual rights are just not able to be exercised by individuals. You just don't know enough. It's too hard, and people don't have the time. So we need real mechanisms here, and there are things I think can work. I think regulation too can't be so specifically tethered to technology that it then becomes obsolete in a second. So the broader principle-based types of regulation. I mean, I really like, the FTC Act kind of has almost a constitutional like law. It's
the
just
unfair practice.
Don't be unfair, don't be deceptive, and that has gotten a lot through enforcement to flesh out what those mean. It can evolve over time. It's really good. Unfortunately, now we're seeing the downside of this is that the FTC is essentially I don't know what it is at this point, but it's kind of been decimated. But the other thing that needs to happen in the regime is meaningful enforcement. And I think for a long time there was the quip that the EU has strict law not enforced, and the U.S. has hardly any law but strictly enforced. But I think that all that's not totally accurate. But enforcement generally has always been pretty weak.
I would add one thing. It's very sector specific. So usually, I mean, we joked in Austria with the Austrian regulator, the privacy regulator here. We got them basically on the front page of like the BBC website, the Austrian version of it, the public broadcaster, which is like the news page of every Austrian that they open in the morning. And we got them on like the cover because they had a Court of Justice case that they lost. And one of the quotes I put in is like Vienna has, I think, 7,000 penalties per month on wrongly parked e-scooters, but the privacy regulator has 60 cases a year decided. So just to put that in perspective, and they hated it because it was so painful. But I think that is what is very specific to the digital sphere. Is what we see is that every judge that sees a computer and that sees the GDPR gets a heart attack and just hopes to get rid of the case somehow. And that is a bit the problem, that we're not up to speed for that, so to say. They know how to regulate buildings and everything else, and also enforcement. I mean, I employ 25 people here, and each year there's some inspector coming in, checking if our desks are, proper, and if, I don't know, people could fall over the stairs or whatever. Fair enough. I mean, to be frank, it probably is good that people sit on a desk that is straight, that we don't pay shitloads of money later in healthcare, but that is all done. That's not a problem. In the tech regulation, we have a very specific problem, that this is for them still a situation where, even to give you an example, we had the Berlin DPA send us a scan of a fax of a submission from 4.5 years ago from the other party now. It's just this is how they regulate it, and that's very specific to this tech sector. That is really, really bad, and quite amazing.
Yeah. So
if we regulate bridges that way, they would all collapse tomorrow.
I want to end on one last question, because you mentioned the new class action rules, what you call collective redress. In the U.S., this is the private right of action, and we have a very robust system with that. When we have laws that have private rights of action, privacy laws, they can really be powerful and pack a big punch, like the Illinois Biometric Information Privacy Act. We can have privacy litigation that really does have strong enforcement. And some of the earlier privacy laws have a private right of action, the TCPA, and there's others, and they can be very potent. So I actually think it's a great enforcement tool, this has always been a difficulty in the EU. I'm curious what you think the future of that is now.
It's mind-blowing, and I think people fundamentally underestimate it. So how to start? Basically, it's a specific. So we always had a private right of action under the GDPR in Article 79. But the problem is, you ask for, so damages in Europe are extremely low. If in Austria you end up in a wheelchair, you get 15,000 euros. You get all your legal costs and all your income that is lost or whatever. But just the fact you sit in the wheelchair is like 15,000 euros, which compared to the US is insanely low. But generally, non-material damages in continental Europe is super low. So we usually talk about privacy cases being $100 or so. or $500 or so. But because you're liable for losing the case, which is the kind of loser pays principle, the average person is not going to do it, because you may end up paying a legal bill of $5,000 for damages of 500 euros. And the average consumer, even though you may win 90%, is just going to be like, too risky, not going to do it. So the only way that you enforce that is through collective redress, by pooling people together. And then suddenly the litigation cost per person gets like way down into a couple of euros. And then suddenly all of this makes sense. The law was actually passed after Dieselgate. So because we had the same issue with Volkswagen, each Volkswagen customer had to separately sue Volkswagen. So you have hundreds of judges dealing with exactly the same problem, which was just insane. So this system now exists. What you need for that, and it's very different than class action in the US in many ways. And the hopes is that the craziness of US class action is not going to happen while you have the benefits of it. We'll see how it works out. But basically, you need a qualified entity, which has to be a nonprofit organization. That is the litigant. That's the claimant, so to say. So you don't have a lead plaintiff or so, but the nonprofit organization is the plaintiff, so to say. And anybody else can then join that. So it's an opt-in system. And they can say through basically filling out a form that they want to join the outcome of this litigation. And with this opt-in system, you can group 1 million people, 2 million people, whatever it is. That's the first type of, and that's usually for damages, for any kind of monetary return, for any kind of like compliance with consumer rights and so on. Then the second thing that you have is a injunctive relief that basically is only between the nonprofit organization and the company, but is erga omnes, so it basically applies to everybody else. And that comes out of the Unfair Terms Directive, so the kind of terms and conditions laws in Europe that basically prohibit any kind of unfair terms and conditions. So 99% of American terms and conditions in the EU would just be unenforceable. And traditionally there was this option for nonprofit organizations to sue a bank, for example, to say you are not allowed to use this type of terms and conditions in commerce anymore. So it would not be the FTC, but a consumer rights organization that does that. And they now expanded this to a whole list of laws. And the GDPR, the whole GDPR is covered by it. But it's a list of, I think, 50, 60 laws where any violation of this law, you can file an injunction. And what you usually do is that you go to a company and say, stop this practice. You define the practice. And you usually have a contractual arrangement beforehand, and most companies settle this. So they basically say, I'll stop it. And you have a contractual arrangement where you say, if for each day that you continue doing that, I'll get, I don't know, a shitload of money. If not, you can go to the court and then basically stop that practice as a whole. And that would also then expand to anybody that is not joined in, that's not an opt-in system, so to say. And that could basically be forward-looking, so to say, don't do that in the future anymore. While the kind of damages, especially in the GDPR situation, is more backward-looking. So you basically have these two options. And to give you an idea, how I always joke about is like, if you look at Meta, they have, I think, 300 million users in Europe or something. If you just have 1% of them, that's 3 million people. If each one of them gets $500, you talk about numbers that actually are, that will trigger, I don't know, the stock exchange quite a lot, even if you're one of the very big tech companies. So that could
still lose your pays, right? That's still the same. With the injunction, is it the same, or is it not?
So it's loser pays, and that is a general rule, and that means very different things per member state. So in Austria, that's 10,000 euros or whatever, easy enough. If you talk Ireland, that's 10 million euros maybe. So that's a big question of which jurisdiction you go to. You can usually combine this with what we call procedure financing. So in Europe, it's usually absolutely prohibited that the law firm finances the litigation. So quota litis and so on is absolutely prohibited. The normal thing in the US is just absolutely off the table in Europe. So this financing part is usually a separate company that basically has a contract with the nonprofit organization, and you opt the people into that to typically say, if we win, you get, I don't know, 10 or 20% of the share. It's usually something in that ballpark for the procedure financing company, and they cover all the costs if won or lost, or, pre-finance everything. Because the big problem is this cases take 5 years and you need to pre-finance all of that and so on. And the law firms also need, they can't work for nothing for 5 years. So that is usually separated in Europe into two different buckets. In some countries, there is also option for philanthropic funding, for government funding, for stuff like that. And that's, again, the funding part of it is per member state. So in each country, that's very different. Again, for the big tech companies, they're usually in Ireland. The big problem is that in Ireland, there is a law from 1600 something championing maintenance. that makes it a crime to get financing from someone else. So they pick the right jurisdiction for hiding from a lot of that. But you can usually bring the cases at the home jurisdictions of consumers as well. So you can basically tell them to go to Germany or France or wherever you want to bring your case, and then they have to come to your place. You don't have to always sue at the defendant's place.
Yeah, I wonder in the future if if or when they ever update the GDPR, if the one-stop shop enforcement system, where companies just can choose wherever they want to be regulated, will change, because I think that's been a sore spot. But I don't know,
that would be hard to do. What I think what's realistic is that the function, and that's something I would support as well, is that the very big tech companies, and we do have that in banking regulation as well, that the very big banks are not nationally regulated because they have a systematic risk for the whole European Union. But they are then regulated on a European level. And that could happen for privacy cases as well, that we basically say the very big tech companies that are defined, for example, as the PCLOBs in one law, they are regulated by the European Data Protection Supervisor. That's currently is only in charge of EU, so to say, federal offices. And that could be a way to kind of bypass that situation, which is realistic and probably is going to happen sooner or later.
Yeah. Well, I could go on for hours. This has been so fascinating talking to you. Thank you for chatting with me, for your candor, and for being so interesting and thoughtful. It's really been a pleasure chatting with you. And we'll see how everything unfolds. I think there's going to be a lot of fast-moving developments over the next few years.
Sad and exciting times at the same time. Thanks a lot, and thanks for everybody listening in.
Yeah, thank you.